Your daughter just got married and changed her last name. And now you're probably wondering, well, do I need to update my will, my trust, and the rest of my estate planning documents? Hi, I'm Chuck Roulet. I'm an estate and elder law planning attorney licensed to practice in both Florida and in Minnesota. And in my nearly 30 years as an estate planning attorney, this is one of the most common questions I get. And the answer might surprise you. So stay with me because I'm going to share exactly when you need to update your documents, when you don't, and the one mistake that could cost your family hundreds of thousands of dollars. Now, before we begin, if you haven't already, make sure you click the like and subscribe button so you'll be notified when I post new videos like this one. If you have a question, post it in the comments below and I may answer it in an upcoming video. And if you stay until the end, I'll share some resources where you can discover more. So here's the truth. If your estate planning documents were professionally drafted, you probably don't need to update them right away. And here's why. So for example, when I draft estate planning documents for my clients, I don't just write, well, I leave everything to Jennifer Smith. That's what you see in do-it-yourself documents. Instead, I write, I leave everything to my daughter, Jennifer Smith, born March 15th, 1985. You see the difference? The relationship doesn't change when she gets married. Jennifer Smith becomes Jennifer Johnson, but she's still your daughter. The legal relationship is what matters, not just the name. Now, let me tell you about Robert and Mary. I created their estate plan when their three daughters were young. Fast forward 15 years. All three daughters are married with different last names. When Robert passed away, his older daughter, Sarah, was now Sarah Martinez, not Sarah Wilson. Was there a problem? Not at all. Because the trust identified her as my daughter, Sarah Wilson, born March 15th, 1985, her identity was clear. She simply signed an affidavit confirming she was the same person and everything proceeded smoothly. Banks and financial institutions see this frequently. They're used to it. Now, there are three situations where updating makes sense. First, and this is big, if it's been more than 5 years since you reviewed your estate plan. And here's why this matters. I just worked with James and Patricia. Their daughter's marriage prompted them to call about a name change. But when we reviewed their 8-year-old trust, we discovered they were missing out on hundreds of thousands in tax savings because the laws had changed. Second, if you're already making other changes, adding beneficiaries, updating trustees, changing distributions, then yes, absolutely update the names too. It's simple to make those changes at the same time. Third, if you just want peace of mind seeing your daughter's married name in your documents, that's perfectly valid. Peace of mind has real value. But here's what really concerns me as an estate planning attorney. Most people use a name change as an excuse to avoid looking at their estate plan altogether. They think, well, if I don't need to update it, I don't need to think about it. And unfortunately, that's dangerous thinking. For example, I recently helped a widow named Margaret, whose husband's estate plan hadn't been touched in 12 years. It worked technically, but their family missed out on over $300,000 in tax savings and had zero asset protection for their kids. I also recently helped a couple whose plan had been drafted by another law firm many years ago and had been done when the federal estate tax exemption was much lower and their estate was larger. And their trust used an outdated strategy that not only was no longer necessary, it would have added undue complexity upon the passing of the first spouse. So in addition to updating their daughter's last names, I simplified their plan for them by removing the unnecessarily complex and outdated strategy. Now, there are some special situations to consider. If you have a blended family, if your daughter will be managing your digital assets, or if she'll be involved in long-term care decisions, having current documentation becomes even more important. And here's something most people don't think about. Modern estate planning includes sophisticated strategies to protect the money you leave your kids from divorce, bankruptcy, and creditor. And these weren't commonly available even 10 years ago. So here's my recommendation. Whether your daughter's name change requires an immediate update or not, use this as your reminder to review your entire estate plan. Now, if you would like to discover more or to schedule a consultation to review your plan, visit our website at rouletlaw.com. I'm also hosting an exclusive masterclass where I'll reveal the strategies I use with my private clients to help them avoid probate, save on taxes, protect the money they leave for their kids in the event they get divorced, and much more. And you can join us by clicking the link in the description below to sign up. Remember, your family's financial security is too important to leave to chance. A name change might not require immediate updates, but it's the perfect reminder to ensure your estate plan still protects your family the way you intended. I hope you found this video helpful, and I look forward to seeing you in an upcoming video and the masterclass. Be well.